City. Good Scott. Scott's always good for this. And thank you, because that rolls us perfectly into time to get started. Welcome, everybody. Excited to have you in class today. Today's class is all about the First Amendment, and we're going to focus on two clauses of the First Amendment that narrow down and look at religion. So there's not just one part of the First Amendment on religion, there's two. My name is Carrie Sautner. I'm the Chief Learning Officer here at the Center. And as we go through class today, feel free to send me as many questions as you want in the Q&A or the chat. I'll weave them into the conversation. And we love questions. I ask a million questions. And our scholar, Tom Donnelly, who's one of our top scholars at the Center, is going to guide us through all of this. And he loves questions from us. He never shies away from the 8 million I ask him every single day. So Tom, how excited are you to get started and to jump into this fun topic?
Very excited. So much to get through.
So much to get through, so much to do. You know, one of the big ideas that we talked about last class before we dive into it is that this is kind of a tricky area, that there's a lot that is not completely settled in the realm of these two clauses. And do you want to kind of set us up about these cases that we're going to look into and how there's a lot of 5-4 splits?
Yeah, I mean, so the religion clause cases, they are among the most hotly contested. They're among the cases where you're most likely to find dissents. And it's just an area of the law that moves quickly over time. And it's moving quickly right now. And so even as we go through, we're going to touch a lot of different topics. The thing to keep in mind is also pay attention to what's happening at the Supreme Court, because these issues are continuing to evolve.
And I love when our classes are so current event focused too. So let's start with a little foundational knowledge. Let's look at the First Amendment. And I love this visual graphic because it really does show you the cornucopia of the First Amendment. There's so much in there. And then we can look at the words of the First Amendment and dive into the two clauses, one that talks about establishment of religion, and the other one is the free exercise of religion clause. So Tom, do you want to talk about do you want to look at the First Amendment together first, but talk about the whole bigger purpose and then how these two pieces fit under that umbrella of the First Amendment?
Yeah, absolutely. So, I mean, my old teacher, Akil Amar, likes to look at the First Amendment as it's a bundle of different rights working together to serve a really big purpose. And so, you know, with the Establishment Clause and the Free Exercise Clause, the religion clauses, they're going really to our belief, our freedom of belief, our freedom to worship or not as we'd like. But they work together with the other rights that you see in the First Amendment, the right to free speech, a free press, and then right to assembly and petition, all together to go to, on the one hand, our broad freedom of conscience in this country, but then working together with those other rights, also our ability to communicate our ideas, even if they're ideas that a lot of people disagree with. It's that scope of freedom that allow us to believe what we want to believe, and then to share it with our fellow Americans, and at times either disagree with them or even sometimes persuade them.
And I love that. It fits so nicely into the whole theme of this entire month is you have the right to think as you choose, you have the right to share these ideas, and you have a right to listen and maybe be persuasive too. And it's all around your ability to have freedom of conscience. And religion is at a key of that. And I know you're going to dive into this, but why it was so important to have not just one clause in here, but two for the people writing the Bill of Rights. So why don't I turn it over? You can walk us through the actual First Amendment, and then we'll dive into each clause.
Sure. We always like starting with the text of the Constitution. Here, it's nice and short, it's tight. So here's the First Amendment. Congress shall make no law respecting an establishment of religion. That's the Establishment Clause. And then that next part, or prohibiting the free exercise thereof. That's the Free Exercise Clause. Those are the two big parts of the Constitution that have to deal with religion. They're in the First Amendment. The Establishment Clause goes to the idea, it prohibits the government from establishing or creating religion in any way. In a real broad sense, it's one of the reasons we don't have an official religion in the United States. It's a way for the founding generation to say, at least as to the national government with the First Amendment, we don't want the national government in the religion business. So, I mean, that's the Establishment Clause. That's that first part. We'll talk a little bit about the history of why it's in there in a little bit. But first, let's say just a little bit about the Free Exercise Clause. So it's working together with the Establishment Clause to give us all the right to worship God or not as we choose. And so that means the government can't punish you because of your religious beliefs or because you don't belong to a church or believe in God. By the time that the first Congress and James Madison are putting together the First Amendment, one of the rights that's most broadly protected by the state constitutions that existed at the time was this right to free exercise. It was very much in the air as we were creating the First Amendment.
And I think it's so unbelievably important that when we talk about this right to have a religion or not, and that two-sided angle of the free exercise clause. And when we look at the colonies and we look at how, colonists came to North America, Native Americans were already there. They came for a purpose and a reason, but also at the same time, there was disagreement among how they were able to exercise their religion. So I always find it fascinating for the groups of people to come to North America to set up their own religion, also at the same time told that other people, you need to be a part of this religion. So it was almost a little like they wanted it one way and then they taught it a different way. So let's dive into that colonial period and how religious liberties, here in Philadelphia, it's huge. Here in Philadelphia, you see, very much following that First Amendment. You can have religion, you can have as many as you want. It's a big part of Philadelphia history. But tell us a little bit more about how it spread out throughout all the colonies.
Yeah, so there are two really big things happening in colonial America when it comes to religion. On the one hand, we have to remember that our nation was born in religious diversity. And so a lot of the people who were coming from Europe to the United States, they were oppressed at home, they were religious dissenters, and so they wanted to be able to worship freely once they got to America. So as a result, as you go state by state, you could just see a slew of different religions growing in the United States. So we had Puritans in New England, we had the Church of England down south, we had Quakers and Lutherans in Pennsylvania, we had Roman Catholics in Maryland, we had Presbyterians throughout the middle colonies, we had Jewish congregations all the way from Newport, Rhode Island, down to Savannah, Georgia. And so if you were to look at a map of the United States here, you could see a lot of different religions growing in different parts of the country. And so we're a nation of religious diversity. But the other part is we see early on in the colonies, we were also a nation of established churches. And so, many groups are coming as dissenters from Europe. At the same time, they established churches in the United States. So we see, again, all throughout the Southern colonies, we see the Church of England established as an official church. We see Congregationalist bodies up in New England. So this is the Puritan tradition. And so what does it mean to have an established church? What does that look like? Well, you might have colonial officials giving out licenses to say who can be clergy, so who can preach. You might have taxes that you're required to pay, whether you're a believer or you're not a believer. You might have requirements to attend church services. And the other part of this, though, is if you violate these different rules, for instance, if you preach without a license, you can be charged, convicted, and then banished from the colony. So think of someone like Roger Williams in Puritan, Massachusetts. He disagrees with a Puritan establishment. They say, Roger, that's awfully nice, but you can now go into the wilderness. See how you do. It's pretty cold out there, pretty dangerous. Roger Williams would do well. He'd establish Rhode Island, but it gives you a sense of this mix of, at the aggregate level, diversity, but also established churches at the state and local level. I'll pause there, Craig, but that's at least one way in which the Establishment Clause in particular is responding to some of those concerns.
Yeah, and I think it's really interesting. We were talking about last class about Anne Hutchinson, another good example of somebody that said, no, this isn't right. But Tom's not kidding when he says, no, seriously, you can go out into the wilderness on your own. That breaking apart of this established religion in the colonies meant you were really on your own and at times in dire straits, and this did not always work out well. So that religious group would also keep you safe, make sure you could get through the winter, have enough support and food. So all of those things are at play here, and we're watching them happen in the colonies. And we're, as Madison and others are coming into writing the Bill of Rights, they're worried about that. They're worried about how this could happen in a way with this new government, and the new government should stay out of the business of picking a religion or not. So that leads us really nicely into looking at the First Amendment. And Tom really set it down for us. This is when we first get the First Amendment, it's talking about Congress. It literally says it right there. So that's the national government. How does this play into federalism? And when do we start to see things change where the states don't have religions of the state, because that happened.
Yeah, so I mean, the First Amendment, the Establishment Clause, when it's first written and ratified, it applies only to the national government. And so what the idea here is, it's not so much about broad religious liberty in like a libertarian sense, but it's more of a federalism provision. So this is about deciding which powers go to the national governments, which powers go to the states. Here, what the Establishment Clause is saying is, one, national government, you cannot establish a religion, full stop. Other countries have established churches. National government, you cannot do that here. It's not going to work in America, in this religiously diverse nation. The other part for some states, though, is also, by the way, you also don't have the power to disestablish our established churches in the states. And so it really is, in that sense, blocking the national government from getting involved in establishment of religion in any way. As we get to the founding, we already do, though, have some states that have moved away, that have no established church. So places like Delaware, New Jersey, Pennsylvania, Rhode Island, parts of New York, you'll see a move away from the establishment of religion there at the state level. And by 1833, all states had disestablished their churches. So we already see by 1833, states on their own have gotten out of the establishment business. So the question then becomes, what does the Establishment Clause, what does it do then? If it was originally this federalism provision, what is it in place to do? And so, part of that is, over time, we see initially the Establishment Clause only applying to the national government. From the 1940s onward, the Supreme Court decides that it also applies to the states. So this is through the 14th Amendment. This is what scholars call incorporation. It's how the Establishment Clause, like the rest of the Bill of Rights, becomes not just something that applies to the national government, but it applies to all levels of government. And so it makes the Bill of Rights and the Establishment Clause a true charter of national freedom. It was written by John Bingham, who's sitting right over my shoulder here. The 14th Amendment was this idea that we're going to apply these rights against the states. But over time, what we've seen is, as we've had more and more Establishment Clause cases, these cases really do closely divide the justices. There are some big things that the Establishment Clause where scholars and justices would agree. As to religion, yeah, it really would be a problem if the state told you who could be your clergy, what your religion, what you had to believe as a religion, those sorts of things really intermingled with religion in that sense. Broadly speaking, we would say that would violate the Establishment Clause. Furthermore, scholars across the board would also say, if you're the government and you're giving out benefits and you give some benefits to one religion and not to the other, and you don't have a non-religious reason for that, that would also be highly problematic. But broadly speaking, these cases, again, Curry, they're highly divisive. Part of the problem is that the court itself, many justices seem to not like the test that they've come up with for Establishment Clause cases. So the big test here is the Lemon test from 1971. But if there's one thing we know since 1971, it's that justice after justice after justice would love to have a different test. The Supreme Court has never overruled it, though. It's still good law. So you should know it. I'll tick through it quickly. Even though the court sometimes often doesn't even apply it anymore, it's still there on the books. It's still there as part of the doctrine. And it can also give you a sense of the sorts of factors that the justices are looking at when they're looking at Establishment Clause cases. So here's the Lemon test. It's very simple, 3 parts. 1, the statute must have a secular legislative purpose. So if there's a law or something being challenged that the government has done, it has to have a non-religious purpose. That's sort of a really big one. 2, its principal or primary effect must be one that neither advances religion nor inhibits religion. So this is the idea, and you'll see this in some of the cases where, at the very least, we'd like to see a neutrality towards religion. You don't want to push religion too far forward, but you also don't want to really harm religion in certain ways. And finally, the statute must not foster an excessive entanglement with religion. It's where we just don't want the government and religion really intermingling too much. So that's really all that the Lemon test is getting at. But really, to see how the Establishment Clause is alive today, Curry, it might be best to just tick through a few of the areas where the court's hearing a lot of cases.
Awesome. And I want to kind of tee up Ken's question as we dive into these areas, because it's not so black and white. It's a lot of gray, and finding where that right line is. So Ken brings up, in the Constitution, it is not stipulated a separation of church and state, but we hear it from everybody. We hear it from politicians. We hear it from community members. You hear it a lot. And it's this idea of this giant thick wall in between the government and the church. But really what we see is that little bit of overlap, not excessive entanglement, but it's sometimes really hard to find those boundaries and those lines. And the courts have shifted over time So Ken wanted to know is how does the First Amendment really address this? And it's really how does the courts address this? And I think that leads us perfectly to look at kind of the three big buckets of the types of clause cases that have come to the courts and how they've sat or how the cases have turned out over time.
Yeah, I mean, the answer is it's really tricky. The justices have a really hard time with these areas. And it's why, as we take through these, I want to emphasize these are areas where you're going to find often a majority opinion and a dissent. You're going to find smart scholars on one side and on the other side. So these are really hard questions. And the issues themselves shift over time. Often they turn a lot on the facts of an individual case as well. But the three big buckets here for Establishment Clause is government funding, government-sponsored prayer, and religious symbols on government property. So let's start with government funding. This is a situation where, the government may have a program where it's giving out money to a bunch of different groups. And the question is whether the government also has to include religious groups or religious schools in those sorts of programs. And so we see really two camps here battle it out in these cases. It's scholars and justices on one side, scholars and justices on the other. The first group says that the key rule here has to be neutrality. You can't treat religion any better or any worse than any other organization. And so maybe you'll have it. So you really, in the end, this view ends up allowing relatively more benefits and more money flow into religious organizations in this first group of scholars. But it's really a question of treating religion no worse and no better than other organizations. So if you're going to give the example in a recent case is if you're going to have a state program that's giving money to put out mats in a playground to keep kids safe at a daycare, you have to include the religious and the non-religious. That's sort of this idea of neutrality. The other camp, though, says, no. It's very dangerous when government is getting involved in giving money out and it's going to religious organizations that are often promoting religious messages. And so because of that, we need a bright line rule. If there's a real danger that this money is going to end up flowing into and benefiting the advancement of religion, we just can't have funding in that context. And what we see over time, Curry, is that the court has fluctuated one way, then the other in which approach it's taken. So, initially the court takes the first approach of neutrality. And so this is something like allowing busing to religious schools. That sort of being an example of, if you're going to give it to non-religious schools, give it to religious schools too. Then in the 70s and 80s, we see a shift more towards the bright line rule, trying to limit the amount of funding that's going to religious organizations and schools. And then finally, I'd say in the last 5 to 10 years, the court's shifted again more into the direction of neutrality, sort of allowing relatively more money to flow into religious organizations and schools. But again, it's one where these cases often draw dissents, and the justices certainly disagree over the best approach and have for decades.
Yeah, and I think it's really important that this is like a moving target that we're seeing over the years, and we'll continuously look at that. And the next kind of bucket that we'll dive into is government-sponsored prayer. And I think my favorite part about these two images is it's clearly talking about kids and talking about schools. And this will come at a difference with the next bucket of what's it like when we talk about government-sponsored prayer in schools? And then what is it like when we have prayer in government entities where adults are? And so age matters, and there's a big part of that as well. So dive into these next two, and then we have a question that's coming up in a little bit that'll be a good wrap up for this section.
Perfect. So government-sponsored prayer. Yeah, you're right, Curry. It's sort of two different domains. There's kids and there's adults, and the court has come out differently in the two contexts. For the Establishment Clause, in many ways, the most famous set of cases are these cases dealing with government-sponsored prayer in public schools, decisions like Engel versus Vital, Abington School District versus Shemp in the 1960s. And these cases say that it's unconstitutional for public schools to lead school children in prayer or Bible reading, or even to have prayer on a voluntary basis. And so, this was a set of decisions that was very controversial at the time, led to great public backlash. You see in Congress many proposals to try to put forth constitutional amendments that could overturn these decisions. But ultimately, the Supreme Court held its ground, and it even expanded these cases into different areas as we get into the 90s and into the aughts, where in Lee versus Wiseman, it extends this line of cases to graduation ceremonies in public schools. And in Santa Fe Independent School District versus Doe in 2000, it extends it to football games. And so again, this is an area where people still debate the outcome of those cases. Those cases also, drew dissenting views. But in the end, the court has sort of, in the context of kids, has sort of said, no prayer in this context. And it's a really protective set of decisions. In part, what seems to be animating the court in this context is a concern that age really makes a difference. It having the government's imprimatur, the government's stamp of approval, has a big difference. And there's a concern with maybe coercing children into religious beliefs in that context, where they're really a captive young audience. But you're right, Curry, the Supreme Court has taken a different approach when it comes to adults. So in the context of legislative prayer, a case called Marsh versus Chambers, and in the context of a prayer at a town council meeting, a case called Town of Greece versus Galloway from just a few years ago. The Supreme Court has said that prayer in that context, at the beginning of a government function, a government meeting or something, that's okay. That's constitutional. In part, what the court has said and relied on is the idea of history and tradition, where this is just something we've done all the way extending back to Washington. And so we're not really going to disrupt that tradition over time, absent a really good reason. So that's the prayer decisions, Curry.
Yeah, and I love that idea of tradition, because it starts to I remember Judge Rendell, who we had on a couple months ago in our class, we asked her about this. She's like, well, the court is not going to come in and disrupt tradition unless it's extremely violating. If it's a common thing that we do and it's not favoring one over the other, we're not going to mess with it. And I was like, oh, I really like the way she explained it. She's like, but it's different in the school setting. There is a case coming up soon that does look at in the Supreme Court this year that looks at football games again, and a coach praying an optional prayer at the football game. Correct, Tom?
That's right. It's Kennedy versus Barrington, I believe is its name.
Cool. So just as always, keep an eye on the courts this year, because we're seeing one come out this year and how it will come out. So as we kind of wrap up this question on this section and look at a little bit maybe in the endorsement test, I just wanted to throw this question from Caroline out at you as we go into the end of this half. There's my football analogy for the first time ever. What is the source of legitimacy, rights, litigation, rights, and even law in an increasing secular society, one even that could be considered hostile to the notion of a deity, one that considers truth relative and the moral codes developed over a millennium of human experiences to be oppressive? So kind of looking at how have we seen the courts over time looking at religion? Is this something that we have seen becoming more and more, and that's a jump, but they say anti-religion, pro-religion, or some kind of ebb and flow between the two?
I think the court's approach to the religion clauses, it in a lot of different areas was like what we talked about with the school funding cases, where they've shifted back and forth and tried to find some sort of equilibrium. I think broadly, the theory has remained the same, where it's a recognition of the religious pluralism and diversity of the United States, making sure that people do have the freedom to worship or not as they like, and to sort of protect that as a core value, in a core constitutional value. But again, for the court over time, it's been very tricky to figure out how to strike that right balance.
Yeah, and as we get into these ideas of how's the court trying to say, we're not messing with tradition, but we want to make sure we have to be careful when in a school setting where the school authority, the government authority, can have power over the students and influence them. We also can talk a little bit about the endorsement test, that when we have religious symbols on land that is government, is it showing an endorsement for that one religion over others, or a religion over non-religion? Do you want to talk about the endorsement test before we jump into free exercise, the other fun side?
Yeah, absolutely. And the other thing to note about tradition in this context, Curry, is that some of the justices disagreed in Town of Greece versus Galloway. They were dissents. We're just sometimes a tradition, sometimes you're just reading the tradition incorrectly, or sometimes it's a bad tradition. And so justices and scholars still debate over how much weight tradition should have in that context. It's just in the context of some of these religion cases, there's been a sort of even a cross-ideological majority sometimes to look to history and tradition as kind of an imperfect way of approaching those cases. The last set of cases here, Curry, is dealing with religious symbols on government property. Over time, there's been at least a core at the middle of the court that's looked to this question of endorsement. So they approach these are cases like where there's a nativity scene in a government building or on government property somewhere, 10 Commandments displays, things like giant crosses commemorating the war dead. And the question is, does this violate the Establishment Clause? And for some justices, the ones who are sometimes the decisive votes in these cases, it turns on this question of, from a common sense perspective, would a reasonable observer who knows everything that's going on here look at this display as an example of the government endorsing religion and therefore sending a message of discouragement to other believers and non-believers? And so in the context of these religious symbol cases, again, they've come out differently based on different contexts, based on what sort of display it is. Is it a nativity scene, a Ten Commandment display? Where is it? Is it in a government building? And is it in a shopping district? Is it among other monuments on government property? And the court will come out differently based on sort of what sort of display it is, what other sort of displays are around that display, and sort of the broader context.
Yeah, and I think I love this, and I'm highlighting so many words. I'm going to highlight the whole thing. Warren and I in the chat were talking about the case. I think it was in Maryland. It was definitely near DC, where you're going around a circle and there was a religious cross of St. Andrew, maybe, if I get that correct. And they asked all these questions, how do people go by it? This is government land, in that context. And they really broke it down in the court case to look at, would this be considered an endorsement or not? And I think it was put up during World War I or II as a memorial as well. So really fascinating. I'm always looking for ways that when the courts break down the case, what's the methods that they're using to make their answer either opinion or dissent, and how do they really understand it and are explaining it as well?
Yes, that was American Legion versus American Humanist Association from 2019. And part of what the court also coalesced around there was the idea that the cross had been there for a long time. So again, looking at sort of the meaning of the cross over time.
Awesome. Okay, bottom of the ninth, let's go into free exercise clause. So looking at how you have the right to choose the religion and exercise your religion or not. And so how can laws affect people's right to have free exercise?
Yeah, so what do these cases look like? So the way it usually works, these sorts of cases are that the government will pass a law. It applies to everyone. It could be against illegal drugs, against polygamy, against any variety of things that the government thinks needs to be prescribed, needs to be banned. And what happens is the religious objector then comes out and says, no, you are banning something that is central to my faith. And the argument is that this violates the First Amendment's free exercise clause. And the court has to decide in this context, does this general law stand, or should there be an exemption for this particular religious person or religious group? And so over time, what we've seen is the courts come out differently in different cases when it comes to these sorts of challenges. I would say if you're talking broadly speaking, over the course of all of American constitutional history, the government's done very well in these cases. The objectors the government wins more cases than the objectors do, but there's enough bite in the doctrine that religious objectors do get serious protections. We've seen even in the last few years, Curry, the Supreme Court being open to religious objections in certain contexts, especially when they're concerned that religion in some way is being treated worse by the government than secular organizations or businesses. The classic example here, Curry, in the recent years would be the challenges to various COVID restrictions on religious services. So maybe, there was one based in New York, Cuomo, which was based on sort of a governor's order that limited the number of people that could worship at a particular point in time based on how pervasive COVID was in the particular community. And the Supreme Court struck that one down. And part of what they said there was, if you look at how you're treating the church, you're treating the church worse than you are, businesses and other secular groups. And because of that, this is a free exercise problem. But Curry, what we've seen over time is that the court has sort of gone back and forth on these sorts of questions. I mean, the first example is in 1878, Reynolds versus United States. This is the classic case involving the Mormon church. The national government passes a law banning polygamy. And so this is a central practice for the Mormon church at that time. The Mormons come to court. George Reynolds, who's a Mormon, comes to court and says, this violates my faith. It's a violation of the free exercise clause. And the Supreme Court says, no, Mr. Reynolds, you lose. In this context, the government has a legitimate interest to limit polygamy. It's a general law applying to everyone. And so the law has to stand. We also see, though, as we get further along into time into the 20th century, there's a period in the 1960s and 1970s, Curry, where the Supreme Court is expanding rights in a lot of different contexts, providing more protections. Part of that is that they beef up the free exercise clause in that context. So these are cases like Sherbert versus Verner and Wisconsin versus Yoder. In each case, the court allowing the religious objection to go forth. In the case of Sherbert versus Verner, it's a worker who says, I have to quit my job because you're requiring me to work on the Sabbath. She then applies for unemployment benefits. The state denies her those unemployment benefits. And the court steps and says, no, the worker has to win here. Sherbert has to win. The government needs a really, 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 really good reason to justify this burden on her religious practice. And so there's an example of the objector winning. And then Wisconsin versus Yoder involves a bunch of Amish families in Wisconsin. Wisconsin has a law that requires kids to go to school all the way through high school. The Amish families step in and say, no. We are not we do not want to send our kids to school after the age of 14. Once you get into high school, they're going to learn all sorts of worldly things that violate our faith. We are a close-knit community. They can be good American citizens and live healthy and thriving lives within the Amish community. There is no compelling reason for Wisconsin to require our kids to go to school. And again, in Wisconsin versus Yoder, the Supreme Court said, yes, Amish families, you're right. And so there are some cases where the religious objectors win. Should I put the last two cases on the table, Curry, before we finish up, or where's the best way to go?
Yeah, I think definitely the last two cases, and then we have a couple questions, and I think it's going to bring some modern cases into the end and what we should be looking for around this, that I would love to kind of weave in here at the end. So I think we can't do this topic without talking about this case. So go for it.
Yeah, so there are two big cases that come out in the early 90s. The first one is Employment Division versus Smith. And it's going to sound a lot like that Sherbert versus Verner case. We have Native Americans in Oregon who they're working as part of their religious ceremonies. They use peyote, a hallucinogenic drug that's illegal. They fail a drug test on their job, and then they don't get their unemployment benefits. And so they go to court and they argue, this is Sherbert versus Verner. We should win under the free exercise clause. And the Supreme Court, in an opinion by Justice Antonin Scalia, said, no, the government wins here. In the end, this is a law. It's a broad law that applies to everyone. The government clearly has an interest in attacking illegal drug use. And here, you may have a religious objection, but this is a law that applies to everyone. It must stand. If you want an exemption, then what you have to do is what so many other groups have done over time, and that's go to the elected branches and get them to write an exemption into law for you. We, the court, we do not want to be in this business. And so after Smith, there's this question of, does the free exercise clause do anything? I mean, is it really so weak? But the court makes it clear a couple of years later in a case called Church of Lakubi Babaluai versus City of Hialeah that no, there is still teeth in the free exercise clause. And in that context, what happens is members of the Santeria faith move into the city of Hialeah in Florida. Members of the Santeria faith, as part of their worship, it involves animal sacrifice. And so the city passes a law that outlaws animal sacrifice after this community moves in. It writes exemptions for things like kosher butchering. And the question is, after Smith, does a law like this stand? Sure, the city might have some interest in protecting animal welfare, but does it survive after Smith? And what the court says is, yes, in the end, the Santeria people, they win this case. In the end, the free exercise clause still has some bite. When does it have bite? It has bite when it's pretty clear that a law is targeting a particular religion. So what Lukumi is writing into the free exercise clause doctrine is a strong anti-discrimination principle. So the court's going to look at the law, it's going to look at the context, try to see what's going on here. Is this genuinely a law of general applicability applying to everyone? If so, then Smith applies and the government's going to win. Or is it something that's targeting religion or religious believers, treating them worse than other people? Is it discriminatory? Then Church of Lakumali Babaluai is going to win. And in that context, the government needs a really, really, really good reason to prevail. The last thing I'll say, Curry, is as we're moving into the cases of today, there are plenty of justices who say we need to reconsider Employment Division versus Smith and write stronger protections for the free exercise clause into doctrine at the court. There are other justices that disagree, but this is one of the big dividing lines in constitutional law today.
Awesome. Okay, now we have 8 million. We got more questions for you on these topics. One, I'm going to start with Ryan because it's on this topic that we're just ending right now. Ryan's question is, how is a sincerely held belief determined? And where does that come from? Because, yeah, it feels very objective And I don't know if that's Ryan's purpose, but that's what I'm reading into it too. So what is there like a litmus test for sincerely held belief, and where does it come from?
The answer is the court really, 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 really doesn't want to get into that question. It is part of what they look at in free exercise cases, but it's hard for me to think of an example where they've looked at something and said that's not a sincere religious belief. It's just something that courts feel really reluctant to do, evaluating the beliefs of a particular group. I'll say that the sincerity of the belief seemed to do some work in Wisconsin versus Yoder, because there Chief Justice Berger is saying something like, this is a well-established community, it's closely knit. There was like a way in which he's inquiring into that specific context of that one community. But the court, not just the Supreme Court, but lower courts, do everything possible to avoid evaluating the sincerely held nature of beliefs. In part, that could be why the court has settled on an approach like employment division versus Smith for as long as it has, because it is just really hard. Once you provide a free exercise clause that's going to, strike down more laws, that's going to have more strength, you might have to get into more questions about sincerely held religious belief, and that's tough. That could also be why the court has moved into the direction of trying to beef up the anti-discrimination side with the Lukumi case, because that's something where they could feel a little bit more objective, where they can look at something and say, is the religion really being targeted, or is religion being treated more poorly than other similarly situated groups? So a way in which that sort of inquiry about equality seems more in line with what it does in a lot of different contexts than looking at, are you a real believer? Well, what if you're a Catholic and you don't believe everything the Catholic Church says, but you sincerely hold it as a religious belief? That's really hard.
Yeah, and there's like cases. Awesome. I'll go back to their questions and not start my level of questioning. Okay, so how has a question around the cross? I keep saying the turnstile, but it wasn't the turnstile. The cross on the land. And saying, like, in itself, a cross sitting there in government land is seen by many as, and I agree with Hal on this one. I remember hearing this case and not expecting it. So the cross is still there, and they side it with the fact that the cross can still be on that land, correct? Let's just put that at the table. Okay. So my first instinct was like, no way, that cross will definitely move because people are driving by it really quickly. It's government land. I see a cross. I don't have all the context of the land. And the question is, how was it able to stay? What was their finding on it? And then I just want to counter that. I know it's a school setting, but I wanted to counter it with the prayer that was written on a school wall in an auditorium. And it was a one religious prayer on a school wall in an auditorium. And the student said, that's not my religion. It's on that wall. It's looking down upon me. And they did remove that prayer. It's a school setting. It's not a public setting. I know there's a lot of different factors here. But can you kind of break it down for us of why the courts ruled to keep the cross?
Yeah, I mean, what the court had largely coalesced around there is it's a really detailed opinion about the context of when the cross was placed there, why, and sort of what the history of the cross has been over time. And so it ends up being one of these religious clause cases that really look to history and tradition and sort of say, it's been there for a while, it seems to have caused no real disruption. And so we're not going to take down this old monument. It's in that way a small c conservative decision where they just decide to not disrupt the status quo because up until that point in time, it seemed to have provoked no controversy. Using a war cross like that in the context of World War I, they thought was sort of a standard practice that wouldn't be as infused with religious meaning as in other contexts, and because of that, they allowed it. Of course, there was a dissent in that case too, that sort of expressed all of the concerns of anyone who thinks the court might have gotten that wrong, where it's like, in what way is a large cross not a sectarian symbol that the government's endorsing? That's sort of the flip side. So it's an argument from sort of history and tradition in the majority, and then this idea that there's something sectarian about the cross that's different in this context, and so as a result, it should come down. So.
And I really appreciate that our chat is going through the opinion and dissent almost the exact same way that the court did. So I appreciate you all in the chat there. One final question around, are there any religious cases around COVID vaccination? And is there anything you can kind of, that's on the docket, that's being discussed, anything around that was also a question in the chat.
Well, there's nothing specifically on the docket right now. There are lower court cases that sort of involve those questions. You know, a lot of those COVID vaccine requirements do have, not all of them, but a lot of them do have religious exemptions written into them. And so, you know, courts are wrestling with those issues, but nothing like that is up at the Supreme Court right now in sort of like the fully argued docket. I mean, the two big cases coming up in religion at the Supreme Court are the one that you already mentioned, Curry, the Kennedy case involving the high school football coach at a public school who wants to pray at the 50-yard line voluntarily at the end of football games. That's one of them. And then the other one is a case called Carson versus Macon, which comes out of Maine. And this is one of those school funding cases. It involves, the question is if the state is going to provide funds for parents to send their kids to private schools, so a school choice program of sorts, can they exclude religious schools from that program, or must they include them? And so the court has to decide that question as well. Those are the two big religion ones coming up.
Awesome. Tom, thank you so much. I'm going to actually stop the recording and stop